this is where most people are absolutely confused as to how they became a prohibited person.
We're the Armed Attorneys. Today we're talking about the expansion of the prohibited persons list under 18 U.S.C. 922. Now, this comes out of the Bipartisan Safer Communities Act, Senate Bill S2938. This was signed into law by President Biden June the 25th, 2022, and is the law of the land. But we have to talk about this closing of the boyfriend loophole. But before we begin, show your support for the Second Amendment by hitting that like button. And today we're talking about Section 12005. And now this relates to expanding the prohibited persons list for misdemeanor crimes of domestic violence to include people who have had a dating relationship. Under the old law, we're talking about misdemeanor crimes of domestic violence, and those folks really involved current or former spouses, whether it was a formal marriage or if it was common law, cohabitation, people who had children together. Think about baby mamas, baby daddies. But now we're expanding this to include dating violence, and this is what they call the Charleston loophole, the boyfriend loophole. And what are they, when we're talking about a dating relationship, what are they saying now, Edwin?
Yeah, I can't help but have to use my air quotes every time I say boyfriend loophole, because it's not really a loophole. It's just simply something that wasn't contemplated when the law was originally written. And so many states have adopted this dating relationship violence kind of aspect, and now this formally brings it into the federal law as well. And so a dating relationship is basically now newly defined as a relationship between individuals who have or have recently had a continuous, serious relationship of a romantic or intimate nature. And in determining whether or not a relationship meets the standard, the courts will consider basically the length of the relationship, the nature of the relationship, and the frequency or type of interaction between the individuals involved in the relationship.
Yeah, and they specifically exclude, and they stole this right out of Texas law, that a casual acquaintance or ordinary fraternization in a business or social context does not constitute a dating relationship. So it looks like they plucked that right out of the Texas Penal Code or the Texas Family Code, and that's where we get that. Now, we're talking about misdemeanors, so these aren't felonies. Now, they do place some additional limitations on that.
What is interesting is that this definition does include the word recent, former recent. So this is quite a departure from the law as it exists now, where obviously once somebody is a former spouse, they're a former spouse forever and ever and ever. But this does acknowledge that a dating relationship does have an end, and that it can grow stale under the law. And so whoever prosecutes this, whoever's deciding is a disqualified person, will have to establish that the former dating partner was recently former and not an extenuated former dating partner.
Yes. And so let's say a person, a prosecutor proves to a jury beyond a reasonable doubt that the person was in a former dating relationship, and the person's convicted of a crime involving an element of force or threatened force. So that's most of all are assaultive offenses. And it's against one of these, domestic violence people that qualify, including this dating relationship. Now, if it's one of the dating relationship folks, that conviction after 5 years, that disability will go away, assuming that the person doesn't otherwise become prohibited, they fall under some other kind of disqualification, or they're subsequently convicted of another misdemeanor crime of domestic violence, dating relationship, or something like that. So after 5 years of one of these dating relationship convictions, after the person's released from the conviction date, from when they're released from supervision, whatever the latest date is in that prosecution, they theoretically could qualify again to purchase and possess firearms and ammunition under federal law.
This is quite a departure in federal law. And it's a very important one too, because this is the first time that under the statute that a person does have the ability to regain their firearms rights. Prior to this, all of these disqualifications have been permanent disqualifications. Obviously, if you're dishonorably discharged, you're dishonorably discharged forever.
Yeah, you renounce your citizenship. Even if you got your citizenship back, you can't unrenounce it.
And if you are convicted of a felony, it would take a judicial process to take that off your record. But here, under the statute, under the terms of the statute itself, this disqualification will expire after 5 years, provided that you don't have any additional convictions.
Another, good, quote unquote, good aspect of this is that it is not retrospective. This is only applying to convictions after June the 25th, 2022. And it doesn't, go back in time and look and see, are there any, recent or current dating relationships where there was a conviction. And that's in contrast to, when we had the Brady Law passed and how we had folks who pled to maybe even a Class C misdemeanor. And I'm using Texas as an example. That's our lowest level offense. It's like a speeding ticket. Let's say they pled to an assault against a current or former spouse that happened in the 1960s. Well, when the Brady Law went into effect, they became a disqualified or prohibited person overnight, and it because it worked retroactively, and this law works prospectively forward.
Yeah, and this is the way that original law should have been written, and maybe perhaps it gets amended in the future, because this is where most people are absolutely confused as to how they became a prohibited person, because they may have had an incident that today we call family violence, but back in 1980, it wasn't really called, and certainly judicially it was not called family violence. And a lot of people have a hard time wrapping their head around how they could be disqualified for a crime they were convicted of 10, 15, 20 years before the disqualification even officially became a disqualification.
Yeah. And so there was a little forethought in that these are taking place for convictions June the 25th, 2022 and forward, looking at these dating relationships, applying it to those and imposing disabilities from those people going forward. But we hope you enjoyed this discussion. If you're not a subscriber and you enjoyed this discussion, make sure to subscribe. We're breaking down all the new provisions of the new Bipartisan Safer Communities Act. If you have any questions, make sure to leave it in the comments section below. We'll address those in future videos. And until next time, we're the Armed Attorneys.